Yes, thank you. Good afternoon, Madam DPP, Mr. White. And are we to expect to hear Augustus?
My lady, I do anticipate him being here, although I must admit he may be somewhat late because I myself had misdiarized this appeal hearing, and I would have inadvertently shared the misdiarized date with him originally. I have sent him the Zoom details, and I'm hoping he'll be able to join us momentarily.
All right.
My apologies.
I will put 1 minute. I'll put my camera off for just a couple of minutes. And by 2:40, I think we should start. So you can reach out to him and encourage him to be here by 2:40.
Absolutely. Thank you, my lady.
Thank you. All right, Mr. White.
Yes, good afternoon, my lady. Thank you for affording me that opportunity. I have been able to reach out to Mr. Augustus. I've sent him, again, the Zoom details. He'll be joining us momentarily, and I've advised him that we may well have begun. So when he does join and is allowed into the Zoom call,
Okay.
that he'll be able to observe. And so that's entirely my fault, my lady. I'm very sorry.
All right, thank you.
But
Okay, so we can get a start. Thank you. This is the Crohn's appeal, Ms. Clark.
It is, my lady. Good afternoon. My learned friend, Mr. White, as he has already indicated, appears from Mr. Augustus and did so in the first instance in the magistrate's court. I personally did not appear in the magistrate's court, but by way of a general background to the case, my lady, this was a matter where Mr. Augustus was prosecuted, amongst other things, for 2 counts of serious assault on police.
Mhm.
The general allegation was that he, during the height of COVID in April of 2020, coughed in the faces of 2 police officers
Yes.
and said that he had COVID, or technically his quote was, "I have coronavirus," and that he coughed 3 times at the officers. A trial did commence. However, he did change his plea to guilty after the commencement of the trial.
Yes.
And in relation to those 2 counts, was conditionally discharged. And we appeal on the basis that that was wrong in law and unduly lenient as a sentence.
Yes.
I will start, my lady, by admitting fully that the Crown Counsel who was present in the magistrate's court for that sentencing hearing did submit to the court that a conditional discharge was appropriate. It's my submission, my lady, that the court is not bound by a submission made by a prosecutor if that submission is in fact wrong in law.
Mhm.
So that is the sort of general overview of my appeal in this matter. I did file written submissions, my lady. I hope you have them before you.
I do, thank you.
Okay. So, my lady, as I mentioned, I'm not going to go through the entire chronology of appearances, but the plea did come in the middle of trial. So the defendant or respondent in this case would not have been entitled to any discount for that purpose.
Mhm.
If I can pick up, my lady, at my paragraph 9.
Yes.
One of the grounds upon which we rely upon in this appeal is that there were no reasons provided by the lieutenant magistrate for her using her discretion. She merely said that after hearing submissions from Ms. Smith and Mr. White and the defendant, and taking into consideration the contents of the BARC and SIR and the relevant sections of the criminal code, the court is satisfied to sentence the defendant as follows. So she doesn't actually get into the 2-pronged test required.
Thank you.
For discharge.
What page? Those
Yes, my lady,
remarks
just a
made on
moment.
the record, just so I can flag it.
Yes. So, my lady, the remarks start from the court on page 11 of the record. My page numbers are handwritten at the bottom.
Oh, I see. Thank you.
Yes, so page 11.
Thank you. Who's the magistrate?
At the time, she was not senior magistrate, but Miss Anderson.
Okay. Yes.
So, my lady, I did provide 2 authorities that speak to the requirement to provide reasons. The first is, I think it's Almanzar and Nunez.
Mhm.
It was a judgment of then Chief Justice Kawali,
Yes.
and the relevant paragraphs are paragraphs 19 and 20 on page 8.
Is that Mr. Augustus?
I see his phone's on mute.
All right,
lady.
fine, but that is him. I just wanted to
Yes. Oh, sorry. Yes.
note
Yes.
it for the record that he is present. Yes, thank you.
Thank you, my lady. As I was mentioning, the first case is Almanzar and Nunez.
Yes.
It's a 2016 case from the then Chief Justice Kawali.
Mhm.
I was directing my lady to page 8 of that judgment.
Okay. Yes.
And paragraph 19 where the chief said, however, these sentiments ultimately beside the point. The crucial question is whether the record discloses any sufficient grounds for concluding that the learned magistrate erred on a question of law alone. It is not sufficient for the appellant to establish that the magistrate's court merely misapplied the correct test to the facts of the case. The appellant must establish that the sentencing judge applied the wrong legal test. And he says, I am bound to find that the learned magistrate did not err in law and apply the wrong test merely because of the language he used, read in some artificial way, can be construed in that manner. Mr. Richards is correct to point out that the public interest consideration needs to be applied to the consideration of whether to enter a conviction or not to the question of whether or not to impose an absolute or conditional discharge. But this does not mean that the discretion to discharge and the discretion to choose an appropriate form of discharge should be viewed as considerations which are confined in separate sealed compartments. However, in a case where it would obviously be in the interest of two young offenders to be acquitted, the contravailing public interest must surely potentially engage consideration of, inter alia, the following issues: the seriousness of the offense, the mitigating circumstances, and the appropriateness in broad public interest terms of a discharge instead of a conviction. So, my lady, what I submit is that from that, I take it to mean that the Chief Justice was saying that you should have at least some consideration of those three things in when the magistrate decided to issue a conditional or a discharge of any type. And that is not done with respect in relation to this case.
Yeah.
So that is the Almanzar and Nunez. I also provided the case of Miller and Clark, which is also a decision of Justice Kawley, but it was issued in 2014. So prior to the Almanzar one, the chief said in Miller and Clark, if we go, of course that my paragraphs are cut off, but page 3 of 4, my lady has a subtitle that says the correct approach to discharging without convicting under section 69.
Yes.
And he is quoting a case of Dubell and Richards from the previous Chief Justice. If we can go over the page to page 4 of 4, in the final 3 paragraphs, Justice Kawley said, in the present case, it is impossible to determine with any degree of clarity on what factual basis the respondent was sentenced. Having said that, and despite the very valiant efforts of Mr. Rogers to distinguish broadly similar cases relied upon by the appellant, it is at the very least strongly arguable that the discharge imposed in the present case was contrary to the public interest, having regard to the seriousness of such offenses and the normal way in which they are dealt with. In the absence of a complete record, the most the court can say is that the learned senior magistrate erred in law in failing to record reasons for his discharge decision. To that extent, the appeal is allowed on a point of law under Section 4 of the Criminal Appeal Act 1952. But having regard to the deficiencies in the record, to which I refer, well, it looks like Mr. White has been kicked out.
Yes.
Okay. To which I refer, sorry, I lost my place. Oh, yes, I see. To which I refer at the beginning of this judgment, I would propose to make no other order. So the decision of the learned senior magistrate imposed on August 22nd, 2012 stands, and the respondent retains the benefit of a conditional discharge, which was imposed on that date. So again, that is where then Chief Justice Kawley and these appellate courts have indicated that it is a mandatory requirement to have reasons for these discharges.
Yes.
So that is the first limb of my submissions on the appeal.
Can I ask you, in terms of the facts that were relied on, what stage of the trial did the respondent plead guilty?
It was after no case submissions, my lady.
Okay, thank you. You might have said that, sorry.
No, that's fine, my lady. I don't think I pointed that out. I did mention the trial had started, but I didn't indicate at what point.
So the Crowns case obviously had been fully presented.
It had, my lady, yes. The Crown had closed its case. And I believe the ruling on no case to answer had been handed down on the 30th of March. So there was a case to answer.
Right.
So my lady, the second ground or limb of my appeal is that even if my lady finds that it was not wrong in law to not record the reasons, we say the sentence imposed by way of discharge was manifestly inadequate. We provided the case of Plant and Robinson. I don't intend to go through that fully, but my lady would be well aware that manifestly inadequate was defined in Plant and Robinson as a sentence that is obviously inadequate. That is to say, obvious to the appellate tribunal that the sentence is much too low and fails to reflect the feelings of civilized society to the crime in question. It is also stated that a sentence is manifestly inadequate when it is obviously insufficient because the judge or magistrate has acted on a wrong principle or has clearly overlooked or undervalued or overestimated or misunderstood some salient feature of the evidence, it is a failure to apply right principles. My lady, the maximum sentence available for those two counts, pursuant to section 311 of the Criminal Code, is 3 years imprisonment or a fine of $3,000 or both such fine and imprisonment.
3 years imprisonment.
Yes, my lady, or a fine of 3,000 or both.
And you're asking me to substitute a sentence?
I am asking my lady to substitute a sentence. I accept that there has been quite a period of time has passed from the date of the sentence in this matter to the hearing of this appeal. So I'm asking for a period of imprisonment to be suspended. I'm more concerned, if I'm being honest, my lady, with a pronouncement from this court that a discharge in these circumstances is inappropriate.
Right. Okay.
I based this portion of my submissions, my lady, on the fact that it is clear, I say, from the record that the learned magistrate failed to take into consideration the context in which this assault arose. My lady may remember that we were in a very different place with respect to COVID
But yes,
in April.
this was Monday, the 13th of April, 2020.
That's correct, my lady, at a time that we were all
Very sensitive time.
yes, locked down. There were daily, or I should say nightly, presentations from the minister being very descript in how they expected some 700 people to die from this virus. My lady will remember even how the courts were affected. We had to shut down courts. We were having remote court hearings. It was a very serious time for this type of offense, my lady. And we did provide one case, and we submit this case was actually before the magistrate, which is why I say it was particularly offensive that she chose to discharge, even on the submission of a Crown Counsel. There's a case I provided out of Scotland. It should be the case of Ian Lindsay. You should have before you.
Let's see. Yes.
Right, my lady. So this case was actually presented by the prosecutor during the course of the trial. So it would have been fully before the magistrate, so she would have been fully aware. It is a appeal from a prosecutor in Scotland on the basis of an unduly lenient sentence. And that sentence was 4 months imprisonment. And it was considered to be unduly lenient. The appropriate, or I should say the paragraphs that I wish to bring to my lady's attention start at page 7, paragraph 16.
Yes.
It says, in our opinion, the sentence as a generality meets the test of undue leniency. And as I mentioned, that was 4 months imprisonment. And it's a strikingly similar case. The respondent in that case had coughed 3 times in the face of 2 police officers as well, in the course of his arrest for something else, which is exactly what happened in this case. As I mentioned, it goes on to say the respondent has an appalling record. I accept that that isn't necessarily the case in this case at bar. And apart from referring to it as a bad record, the sheriff gave no indication that she really took into account and really took this into account and reflected it in the sentence which she imposed. The respondent's record runs to 11 pages. He's appeared on complaint well over 100 times on 170 charges, as well as appearing on indictment for assault. Of particular relevance are the 30 separate occasions of contravening Section 41A of the Police of Scotland Act and the Police and Fire Reform Scotland Act. The greater majority of these offences was serious enough to warrant a sentence of imprisonment of 3 months or more, and several cases of 6 months or more. He was convicted 3 times on such charges in 2019 alone, receiving sentences of 2, 4, and 8 months imprisonment. The sheriff appears to have considered that it was a mitigating factor that the offence was not planned, was completed in a matter of seconds, and was not accompanied by any threats, violence, or aggression. However, as the advocate deputy submitted, this is to ignore the fact that the offense was clearly deliberate, repeated towards the second officer, and designed to cause significant fear and alarm, which the respondent must have known would be the result of his actions. We cannot see that the fact that the respondent was not displaying COVID-19 symptoms as a factor in his favor. There appears to be a real risk that the condition may be transmitted by those who are asymptomatic carriers of it, even if the risk may be a small one. As the sheriff correctly states, the emergency services deserve and require the protection of the courts as they perform their duties. Assaults upon them or other behavior culpably and recklessly endangering their health or lives in the execution of their duties require to be treated with appropriate severity. The sheriff did not take sufficient account of the fact that the charge to which the respondent pled guilty was of culpably and recklessly endangering the lives of the officers, even if that endangerment was, as is often the case, potential rather than actual. The alarm and distress suffered by the officers was certainly real. Had the sheriff taken full account of the appellant's record, his deliberate and calculated actions, and the nature of the offense, the general risk involved, we cannot see that she would have selected a starting point of less than 15 months. We therefore consider the sentence selected was unduly lenient in being without the range of reasonable sentences available to the sheriff. Similarly, as you can see, other jurisdictions were taking strikingly similar situations rather seriously. And I would suggest that we in Bermuda, particularly at that time, should have also been considered this type of action rather seriously. We did provide, my lady, the case of Brangman, but I know the court is fully aware that no sentencing judge or magistrate could be beholden to any submission by a prosecutor or a defense counsel as to what the appropriate sentence might be.
Yes.
So I don't intend to have to go through Glenn Brangman for that purpose.
Okay.
But we did provide 2 non-COVID related assaults, my lady, on police of similar offenses. They are magistrate's court documents, so you would see like an information and a summary behind it and the GEMS printout so that you can see what the sentence was.
Yes.
The first we provided was Keno Lambert, who was convicted of assault on police. And on that occasion, it was a guilty plea and he was sentenced to $1,000 fine. So
I see. Yes.
yes. And then the second we provided, my lady, was out of Gina Cooper, when she was shouting obscenities, and was also convicted. I think she spat in the officer's face, and she was sentenced to 1 month imprisonment, suspended for 6 months. And she clearly said that she couldn't have community service because of her no fixed abode. So, my lady, it's not unusual for people to be convicted for these types of assaults. And we would submit that the case in respect of Mr. Augustus is far more serious than either of those 2 examples.
Yes.
So in conclusion, my lady, we would submit that the conditional discharge in the circumstances of this case failed to reflect the feelings of civilized society to the crime in question. We say that it was clear from the record that the magistrate has overlooked or undervalued some of the salient features of the evidence, and that she failed to record her reasons. So we are asking and do humbly pray that the appeal be allowed and that the respondent be sentenced in accordance with the authorities provided. So I would suggest, my lady, something in the range of between 3 and 6 months imprisonment, suspended, I would say, for 2 years, my lady. And we say that on the basis that there's been a wrong decision on the question of law, and it was a failure to apply the correct principles, and therefore, in all the circumstances, a conditional discharge was manifestly inadequate.
Yeah.
Those are my brief submissions, my lady, unless you have any questions for me.
Oh, thank you very much, Ms. Clark. Yes, Mr. White. You're still on mute, Mr. White.
Thank you very much, my lady. My apologies. Having heard my learned friend, if I may just indicate from the onset, it's most unfortunate that more detailed reasons were not recorded in regard to sentencing and the 2-prong test of a conditional discharge. We, of course, cannot resile from the fact that those reasons were not recorded. It's in the record. However, I must point out that one must take into consideration what the sentencing magistrate was faced with on that day when the sentence was passed down, and that was Crown Counsel, senior Crown Counsel, submitting that the 2-prong test was met and that the appropriate disposition.
Sorry, who's the Crown Counsel apparently?
It was Miss Nicole Smith.
Thank you.
Yeah.
So faced with that, together with a fully authored SIR report and BARC report, the now senior magistrate, I would humbly submit, can be forgiven for not recording in detail the reasoning behind each prong of that two-prong test. However, as I said, we can't resile from the fact that they are not recorded for perpetuity in the record. That being said, we also, from the onset, accept that on its face, this disposition of a conditional discharge in respect to these two counts is lenient and perhaps very lenient. However, we would very humbly submit that it's not manifestly inadequate in the face of what these matters were. Namely, we'd point out that the senior magistrate had, if I may say so, a glowing SIR report before her, and also uniquely had the benefit of hearing the Crown's case. As my learned friend pointed out, a guilty plea was entered after the Crown's case had closed. So the senior magistrate, now senior magistrate, sentencing magistrate, was in a very unique and well-equipped position to pass an appropriate disposition. And I would very respectfully submit that the sentencing magistrate was in a position that was a better position than an appellate jurisdiction, owing to these unique features. Having heard the entirety of the Crown's case, every detail, as well as being equipped with the SIR and BARC report.
Are you going to highlight anything from what was heard during the course of the Crown's case or the SIR report so that I can understand what it is that
I would
have been underlying her decision? Well, first of all, her absence of reasons haven't been recorded, and then number two,
I'm afraid, my lady, I can't articulate any support for lack of reasons. I can't extract anything from the record and the SIR that goes to that. I don't wish to belabor what would be a bad point as to the lack of reasons, but in respect of the evidence heard during the Crown's case, it was highlighted to the sentencing magistrate, not by the Crown, but by myself, that the defendant, of his own volition, voluntarily stayed at the police station beyond the detention timeline, at which point he would have been technically permitted to request his release and or file a habeas corpus for the purpose of enabling COVID testing to be done on himself and ensuring that he did not, in fact, have COVID. That was a salient feature, I would suggest. It was a very early attempt to mitigate what any anxiety or harm that may have been caused. I would also, again, I was going to wait until we got to the two cases of Miss Cooper and Mr. Lambert that the Crown provided in an effort to distinguish them. I think—
1 minute, please. When you said to alleviate any anxiety during that time, COVID test results, was it not the prevailing thought that there was a period of incubation and a test would not provide you with an immediate position as to what the person's COVID status was, in fact?
My lady, I certainly don't want to speak out of turn on a matter I'm certainly perhaps not entirely qualified to speak on.
We're not asking what the scientific position was. We're talking about the officer's anxiety. So was it not a prevailing view held by the general public, or was it not at least being announced to the general public that there's an incubation period that would affect an accurate reading of a COVID test when taken by someone if they in fact had caught the virus in a short period prior to.
Yes, I think in respect of the officers, yes, I imagine that was the case. I was speaking more specifically to Mr. Augustus, who understandably, given the allegations at the time, was requested to undergo voluntary COVID testing at the police station and did so and remained there until those results came back.
But you talked about in order to relieve the anxiety that the officers would likely have felt. Is it not something that I should obviously take some notice of, that their anxiety might not have likely have been relieved just by, I mean, what were you doing, PCR tests at the time?
Yes, I would very humbly submit that any anxiety they may have had or would have had and did have would have been alleviated upon Mr. Augustus's test result coming back as negative.
When did it come back as negative?
It came back, I believe it was done very expeditiously. I was in the police station during that initial detention, but it was within, and I certainly don't want to misspeak, and perhaps my learned friend, if she has the appropriate witness statement before her, can double check, but within 72 hours, I believe, of the initial incident. It was done very expeditiously, and we cannot, again, deny that there was not fairly Herculean effort down at the police station and the relevant authorities to get that done. But I do think it was a salient aspect that Mr. Augustus, of his own volition, very much wished to remain. There was no efforts by him or instruction to me to secure his release on the basis of any detention timeline. So he spent a significant amount of time in the station for the purpose of ensuring that those results were back and were negative. And it was upon receiving those results in the negative that I would submit that the officer's anxiety and angst would have been alleviated. And later on, when their results, of course, came back also negative, my lady. So in respect of the two cases that the Crown sought to rely on and place before the court, namely the case of Ms. Cooper and Mr. Lambert, I would ask that the court see these as easily distinguishable by reference simply to the antecedent record of those two cases. Both of those individuals, as evidenced by the paperwork my learned friend provided the court with, had extensive antecedents, one running to, it would seem, 3 or 4 pages, and the other running to the better part of 2.5 pages, my lady, whereas the sentencing magistrate had before her in Mr. Augustus an individual with no previous convictions, which again, although not recorded in the reasoning, was of course a factor that the sentencing magistrate would have taken into account. In an alternative position, my lady, if the court finds that the lack of reasons recorded established that the sentence was passed, was wrong in law, we would ask that, regardless of the actual finding on that aspect of the Crown sentencing appeal, that it would be in the circumstances, appropriate not to disturb the sentence passed by the sentencing magistrate. And that, my lady, I submit on the basis that senior Crown Counsel appeared in sentencing court and made the submission that this was an appropriate disposition. And we wholeheartedly accept and agree with my learned friend's contention that a sentencing judge or magistrate is in no way bound by any agreement between the Crown and the defense. We don't seek to suggest otherwise. However, we would suggest it would be inequitable at this stage, regardless of this court's potential findings as to the position at law, to disturb Mr. Augustus's sentence at this stage. I'm alive to the fact that my learned friend's primary concern with regards to this matter is the appropriateness in the future of any discharge for such things. But where we have such a unique factual matrix of senior Crown Counsel appearing in magistrate's court and making eloquent and obviously convincing submissions for a disposition, it would, I very respectfully submit that it would be inequitable to now have a defendant find himself resentenced in the face of it. And we would ask the court to take that into consideration if, in fact, the court is persuaded that the sentence passed was wrong in law by reason of a lack of reasons being recorded. Again, that.
Tell me something. On the 13th of April, that was that an actual lockdown period?
It was, my lady, and it was, the incident happened. Mr. Augustus was deemed an essential worker. I believe it was deemed an essential worker by reason of his employment as a working within the food provisioning grocery system. I hope I'm not misspeaking in classifying that as essential worker. I know that has had different legal meanings over the months, but he was someone who was required and permitted to be traveling to and from work under the then COVID.
What were his circumstances, how he came to be encountered by the police?
There was a road traffic accident, my lady, and he was simultaneous with these charges owing to the same series of events on the same night. He was also charged with driving whilst impaired. And that is what led him to be in a interaction with the police in respect of the counts that the current appeal concerns.
He was involved in the road traffic accident?
Yes. And as a result, the police were called, and he was ultimately charged with driving whilst impaired and failing to provide a sample of breath.
And he was charged with that on a separate information?
No, it was simultaneous.
Okay. Oh, I see.
And he was sentenced, dare I say, in the normal course in respect of those matters. And I'm conscious that the Crown's appeal is solely focused on the disposition in relation to counts 3 and 4.
And the police officers would have obviously been very alert to the fact that there were several thousands of daily deaths on account of coronavirus during that time. We were seeing that all over the world news, weren't we?
Globally, yes. I mean, there again, I don't seek to mitigate what stresses the officers involved and anxieties they would have felt. But again, I would take the opportunity to point out that the sentencing magistrate had heard those concerns and anxieties articulated from the stand prior to passing this sentence. The sentencing magistrate was fully aware, I would respectfully submit.
That's the thrust of the DPP's complaint.
Indeed, but again, I would suggest that the sentencing magistrate was in such a position that she was more than equipped to pass what was deemed an appropriate sentence at the time. It was not as though the sentencing magistrate was operating in any kind of vacuum or had a lack of information relevant to the offenses before her. It was quite the contrary. In fact, it was again, due to the unique facts and the way it came to be sentenced, unusual to have so many of the pertinent facts at the time of sentencing. And again, she will have been aware that Mr. Augustus's young age at the time, his lack of previous convictions.
How old was he at the time of the offense? What was his age?
He was, I dare say, I may ask.
26 at page 13 of the record, my lady.
Yes, that's right. That's right. He is also at the time of sentencing. He was a very new father to a very young child. That a matter I recall spoken about in the course of sentencing, or perhaps post sentencing more appropriately, as to the status of his becoming a new father. All of that was known to the magistrate, and I would respectfully say taken into consideration, notwithstanding the lack of reasons recorded in the magistrate's note, which again I would respectfully say is explicable by reason of the presentation from the senior Crown Counsel that this was an appropriate disposition in light of the offenses charged and the evidence heard and the surrounding circumstances.
Did the then defendant, Mr. Augustus, did he come to explain himself before the magistrate as to why he had committed these offenses? The offense which I'm concerned.
Yeah, my lady, not an attractive explanation, I accept, but at the time it was he was operating under the influence and was unable to articulate certainly any reasoning or frankly recollection of the actual incident. There was no articulable explanation for the actual words or actions uttered at that time beyond being under the influence at the time. And of course,
two charges under section 311D. Is it one charge per cough?
There were two officers sat
I
in.
see.
Yes, I believe that was the basis of the two counts. Yes, there were counts.
I see. Okay, that makes more sense. Thank you.
Specific officer.
All right. Anything else?
No, my lady, unless I can address any specific question or query and clarify any point that I made.
No, I don't think so. Ms. Clark, do you?
I have no response in law, my lady, but I do wish to actually clarify a point. So whilst I accept it was Ms. Smith who was the counsel at the sentence, the trial was actually conducted by a different counsel, Ms. Lisa Trott. So
Okay,
Ms. Smith was not the counsel at trial.
okay.
Yeah.
All right, I reserve judgment and will produce a written decision, which I will hand down in open court. The date in which I'll do that, I think will have to be communicated to you through the registry. Okay?
Thank you very much, my lady.
All
Thank you,
right,
my lady.
Thank you. The hearing is adjourned.